Doctor, you can start. Dr. Shahrizal, your cue, you can start now. All right.
Good morning, everyone. Welcome to live at PTAR, Series 15. And today we're going to have Bicara Buku, book discussions on the book written by Datuk Profesor Sundra Rajoo, published by Sweet and Maxwell, Uncitral, Model Law and Arbitration Rules, the Arbitration Act 2005, and AIAC Arbitration Rules 2018. Allow me to introduce myself. My name is Shahrizal Mohd Zin. I'm a senior lecturer of the Fakulti of Law, UiTM, and also a practicing arbitrator, adjudicator, and mediator. Before I start, let me introduce our guest of honor for today. We are delighted to have Datuk Profesor Sundra Rajoo, and Datuk Profesor Sundra Rajoo need not any introductions. He does not need any introductions. I can describe him as the doyen of Malaysian arbitration and also construction law. However, let me run through his brief CV. Datuk Profesor Sundra Rajoo is an advocate and solicitor, now practicing, registered architect and town planner, Bachelor of Science, Housing, Building and Planning, USM, LLB, London, CLP, Graduate Diploma in Architecture, a Master of Science in Construction Law and Arbitration from London Metropolitan University. He also obtained MPhil, Master of Philosophy in Law from Manchester University, a Diploma in International Commercial Arbitrations, and he was awarded honorary doctorate by the Leeds Beckett University. And Datuk Sundra Rajoo served as a chairman, a co-arbitrator of three-man panels, and also sole arbitrator in over 280 domestic and international arbitrations. And Datuk Sundra Rajoo is also currently a founding president for the AIADR, Asian Institute of Alternative Dispute Resolution, and he was a former director of the AIAC and a former president of the CIArb. All right, I'm going to have questions and answer from Datuk Sundra Rajoo. So without further ado, let me start with the first questions regarding the book on Uncitral Model Law. Datuk Sundra, what motivated you to write 931-page book? And also please share with us its key content.
Good morning, Dr. Shahrizal. I know you are also a prolific writer. I must congratulate you for your recent books on ISD.
Thank you.
And also adjudication. I enjoyed reading them, but it's a very good effort. But today we are going to talk about. I'm actually a person of the past. I like to say that, because the things that I write about, I suppose that the younger generation will take over. What motivated me to write a book, which I think I have it here, which is the Uncitral Model Law. But basically, it was on the Malaysian Act. And as amended and latest amendment was in 2018. One of the things when I was director is that I focused on trying to project Malaysia as a safe seat. There are two parts of actually marketing something, as we all know. As a person, you project actually your ability to do things, but your ability to do anything, let's say you say I'm a good arbitrator, does not mean anything to anyone, because if you want to actually get work, then you will have to actually show that you're able to do it. So I think, the motivation in writing this book is nothing to do with me, was actually trying to show that the Malaysian jurisdiction is one that is progressive. We had actually switched to model law. For those who don't know when I talk about model law, is that there was a template proposed by the Uncitral, which is a UN body, saying that countries should use this template, and which is called the Uncitral model law. And Malaysia actually used that template to set up its arbitration law in 2005. So from 2005, I originally wrote a book with my co-author, Datuk Bill Davidson, on the Act. I also wrote another book called Law, Practice and Procedure of Arbitration. Then in 2005, the law changed completely. And what happened was that in 2016, I wrote the book. I updated to the second edition of the Law, Practice and Procedure. It was just to showcase Malaysia. And 2011, 2018, there were amendments to the Arbitration Act. And we followed the Uncitral Model Law 2006. But we needed to actually explain. My purpose was actually to write a book to explain the latest amendments, look at all the case law, and then it was a commentary going clause section by section by section. So originally, Bill Davidson and I were starting on this edition. It was supposed to be the second edition of the original book. But Datuk Bill was not well, and he could not actually contribute very much. But so he decided to drop out, and I soldiered on. So when this book was ready, the original plan was that this book will be used as a strategic marketing tool to promote Malaysia and AIAC. But I think in 2019, I was no more director. So the book remained as an explanation of what these. There are two parts to the book. One is the model law itself, which is as applied in Malaysia under the 2018 amendments. But then the second part of the book, which I got my good friend, Dr. Thomas Kutzel from Germany, to write on the AIAC arbitration rules. Now, the AIAC arbitration rules is quite unique because, again, we use the Uncitral arbitration rules as the basis, and then we amend it by the AIAC arbitration rules. And there was no commentary ever done in Malaysia on the rules. So I think this book, as it was originally planned, is a one-stop compendium to both the law, and also to the rules of the arbitration rules and the Arbitration Act. I think when we wrote the book, the times were not very, very good for the center, and also not very good for Malaysia, where safe seat principles are concerned. So there was some difficulty. The book was not well received. So I think, but I think one of the important things is that if you write a book that is of good content, what will happen is that when you have the key contents, let's say I have the key contents is the model law, we explain the arbitration rules based on Uncitral model law, then we say how does the model law and the arbitration rules get applied in Malaysia, and then we follow through as the development of the arbitral legislation with the special contribution from outside, and then we comment on important judgments, domestic and international, and show how Malaysia, the center, and all the things people do in the courts are all related to outside, and it is one whole system. Now, one of the things is that I express views in the book. I take a position. Now, normally, when I take a position, sometimes I will say things in a way that is quite direct, but I always try to put a reasoned argument why that should be the position. So I think two parts to it. The book was intended to be informative, but I think the other part is also to stimulate debate. You see, when the things go to court in Malaysia, there's always an adversarial system where people take extreme positions and the court rules what the law is. So we actually also try to present some views so that it could be persuasive and helpful to the courts. And then basically and try to bring about consistency and harmonization. I think that is the most important thing. Thank you, Dr. Shahrizal. I went on a long spiel.
All right, thank you, Datuk, for introducing the key contents of the book. Now, my next question is that the bulk of the book is on the Arbitration Act 2005, as amended in 2011 and recently in 2018. Now, could you please highlight the developments of arbitration legislation in Malaysia?
Yes, arbitration has been here since we have known ourselves to be a political entity. As you know, at that time when the British, we don't talk about pre-British days because arbitration was a different form. But you know, when the British came here in 1789 with the Pankot Treaty and all these things, in 1809 they actually took over Malacca, Singapore, and Penang, and it was called the Strait Settlement. In the Strait Settlement, the first arbitration legislation was done. It was called Ordinance 8 of the Strait Settlements in 1809. So that was actually the first arbitration act that we have. It is then replaced by the 1890 Act. And then after the 1890 Act, the most important in our recent memory, Dr. Shahrizal, you're younger. When I started arbitral practice, it was the 1950 Act. The 1952 Act replaced the 1890 Ordinance. So until the 1952 Act was there until 2005. In 2005, we did a major change. That means we broke away from the English arbitration system. We didn't follow the 1996 English Act. We followed what the United Nations recommended, which is the Uncitral Working Group recommending that we should have a model law. And so by having the model law, in fact, there was a great debate. I was involved in the drafting of the original act when the then AG, Tan Sri Mokhtar, asked the bar to draft, and I was part of the bar committee with Bill Davidson and a number of senior people. We drafted a act. At the same time, there was actually a proposal from another institution, a Malaysian Institute of Arbitrators, where they actually came out with a 1996 act based on. So because of that, there was a little bit of confusion and it took some time. In fact, the debate went on from 2002 to 2005 until I think the government decided that it will follow model law. I always say that this is a very important part of our arbitration history, because if we had gone the English way, which some countries have gone, then we would have been using a different operating system from the model law. But whereas now we are part of model law, we are part of the 70-something countries that are model law, and also we are part of the New York Convention, which is compliant, more compliant. So what has happened is that in 2005, when the Act change became model law, it was completely a new Act. And unfortunately, in 2005, when we put in our Act, in 2006, Uncitral came out with an amendment. And they said, okay, we need to actually, this is the latest amendment, and this was the 2006 amendment. Arbitration legislation to do in Malaysia is very, very difficult. It takes time, there's consultation, there's discussion. So by the time we were ready to go for the 2006 Act, we did a stopgap measure in 2011. That time I was director of the center. In fact, I went to see the Attorney General and said we needed to have some quick fix, and that's when the 2000 amendment came. And after which, then we did in 2018 the very, very important amendments that came in. Now, the first thing to remember, 2005, it is the model law. and the model law as modified. You see, sometimes they give you a template, they allow you to modify, but I think we did not have the full experience at that time. So when we did the amendments at that time, we actually did one thing. We followed the model law, but we did our own arrangement. So that own arrangement sometimes comes and cause difficulty. And then so in 2011, so 2005, the act is you can see from the chart that we adopted the law. In 2006, Uncitral makes a revision. In 2011, we quickly issue amendments as stopgap measure. And in 2013, Uncitral, Malaysia and ALCO continue the host country agreement. Then we have that decision in Far East coming in 2017, which gave the impetus to do the amendments to the Arbitration Act 2018. So you can see that our way we have been doing things is that we have been trying to become a safe seat. We have been trying very hard to become a safe seat. We try to change so that there is actually a legislative arrangement. Now, the key amendments to the 2005 Act is the earlier one is model law. Then they have part 1 and part 2, and basically we have an opt-in and opt-out mechanism. With the opt-in and opt-out mechanism, we basically get to do what is say that it is for international arbitration, which is foreign arbitrations done, and then we have domestic arbitrations. So I think this is quite important. Then in 2011, we had some case law. Then we quickly did amendments. There were limited amendments. Now 2018 is the key amendments. The key amendments, we actually forged ahead of many jurisdictions. The only thing that we did not do in the 2018 amendments is third-party funding, which I think people did not understand it, so there was a lot of objection against it. So to prevent the whole delay, I decided to actually agree to it. So I think the book, when you go back to the book actually discusses all these things and show how our arbitral, the first part of the book, which is the introductory chapters, talk about how Malaysian arbitration has developed, how did the legislation develop, and the role of groups of people eventually getting what we have now. And then we go into the amendments. The key takeaways in the Arbitration Act would be, in the first thing, if you remember in 2008, AIAC used to be called KLRCA, Kuala Lumpur Regional Center for Arbitration. Now, the first amendment was actually changing the name to the Asian International Arbitration Center. So, the real thing is that when we changed to the Asian International Arbitration Center, it also showed our ambition. We wanted to make Malaysia as the center in the Asia Pacific region, because we have two great centers in the world, including Singapore and Hong Kong. So we needed to take that position in Malaysia, so that we become the Asian International. Try by the name itself, we project our ambition, and then we have this competitive, progressive, and powerful Arbitration Act, which the courts try to uphold, and it is modern, so that we are way ahead. In fact, I think some of the other seats started to follow some of our changes that we made. So I think that's where we are, Dr. Shahrizal. Yes.
Okay, thank you, Datuk, for explaining the key takeaways of the 2018 amendment to the Arbitration Act 2005. Now we come to the game changer that prompted the 2018 amendment. The Federal Court judgment in Far East holding case and Majlis Ugama Islam dan Adat Resam Melayu Pahang. So this Far East case has been a catalyst for change to repeal Section 42 of the Arbitration Act 2005. So my question to you is that, is this a desirable way forward for Malaysia on the repeal of Section 42?
Actually, the federal court decision in the Far East Holdings Berhad versus Majlis Ugama Islam dan Adat Resam Melayu Pahang was actually a catalyst. It was a very interesting case because it was a shareholding arrangement, and there were two items that actually the federal court dealt with, which necessitated a relook. Because, in one decision, sometimes, we cannot say the federal court is wrong. The federal court actually interprets the law and tells us what the law is. So when it made the decision in 2017, then basically there were two parts to that decision. The first part, it said that there cannot be pre-award interest. I think you all must remember this, in one blow, one decision, which is actually the interpretation, because the Court of Appeal held there is no provision in the Act talking about interest, pre-award interest. Therefore, pre-award interest cannot be given. There is a provision for post-award interest. Therefore, post-award interest can be given. So the federal court upheld that provision. And what it did in that one go is 40 years of jurisprudence where arbitral tribunals can issue pre-award interest. Pre-award interest is from the cost of the action, to until the award is published. There is a considerable time gap, because when you have the cost of action and there is the breach, and then they decide to do the arbitration, it may take about 3-4 years. For that 3-4 years, basically there is no compensation on the monies kept away. So what actually happens is that particular item of interest became a major concern, because we were the only jurisdiction in, I think maybe in the whole world, that doesn't allow pre-award interest. So, I mean, originally there was not a problem simply because many years and cases and all this, they keep on saying an arbitral tribunal can actually give pre-award interest. So it was not a problem. There was enough case law, and the case law was upheld. In fact, it was consistently assumed that pre-award interest was there. Now, when the federal court held that there cannot be pre-award interest, alarm bells went around, because basically Malaysia is no more a important or a seat that why should somebody arbitrate here when he cannot get a remedy that he used to get, when Singapore can give you that kind of remedy, when the arbitral tribunal sitting in Singapore or Hong Kong or anywhere else in the world except in Malaysia, you can't give. So there was actually a lacuna. And I'm not saying the federal court is wrong. The federal court is right. The federal court ruled and said that, look, I'm not looking at the case law. I'm just looking at the words of the section. There is no interest provision. Therefore, there cannot be interest. I think that actually is the first alarm bell. The second alarm bell is Section 42. Now, Section 42 was something that is quite controversial, even when it was originally done. I was in the original drafting committee of the Bar Council when we decided the Act. And when we did when we came to Section 42, it was decided that for domestic arbitrations, there should be some way of parties going to the court to ask the court for a question of law that is important from an award. This is actually supposed to be for the development of the law. One is for the development of the law, and also to make sure that things things are got right in terms of the law. But the thing is that the same Act has a setting aside provision on dealing with awards. That means the awards are upheld except can be set aside for the following reason. So Section 42 The main failure, I think, in 2005 was when the threshold leave provisions were removed. When the Bar Council first drafted it, they drafted the leave provisions in. We drafted it in. And somehow or other, when the act was actually implemented, the leave provisions were taken out. And when the leave provisions were taken out, it is only logical that parties, whenever there is an award, it says any question of law arising out of the award. When you write an award, everything is about law and facts, law and facts, law and facts. So when you actually come to a situation where a party does not agree with the law, the party will actually go to the court, use Section 42, ask the court, and the remedy is the court can set aside, vary, remit. It can do a number of things which Section 37 doesn't provide for. So for domestic award, that means there is greater chance of interference under Section 42. Now, I think the courts, to be fair to them, they have been very, very careful. They tried to ring fence the thing. In 2011, I tried to propose to reinstate the leave threshold requirement. At that time, there were some people in the Bar Council who were very against it. They said that, look, this is there should be this remedy going to the court, and we should actually be able to argue these things. So that, but we said, look, arbitration is basically supposed to be final. There are provisions to set aside and all these things, but you cannot actually go and redo it as an appeal and then start examining it as going up. Then arbitration becomes an inferior tribunal. Why go to arbitration when there is no end? Because it becomes up like a sessions court. After that, you appeal to the High Court. After that, you appeal to the Court of Appeal. Then you appeal to the Federal Court. But that was okay. That debate was going on, and it was lasting in 2011. But with the Far East case, the second ruling that the court did was it said any provision of any question of law. That means there is no threshold. Any question of law rising out of the award, they interpreted it as any question of law. That means as long as you can show a question of law, you can use Section 42 and the court must entertain you. Now, that was never the intention, because the court can confirm, can vary, can remit wholly or partly, can even set aside wholly or partly. Basically, you had a situation, two bites of the cherry. And at the same time, the uncertainty that comes out, why should people arbitrate? Because if I want to do that, then I might as well go to court and do it until the end. I arbitrate because I want to have some finality. The real change came from the Bar Council. When this decision came out, you see, this is, I think, something that was actually not known to many people. The Bar Council actually wrote a letter on the 23rd. The decision came out, I think, the week before, 17th. On the 23rd of November 2017, the Bar Council wrote to the then Minister, Datuk Sri Azalina, and copied it to the director, that's me at the time, asking for an urgent change to the Arbitration Act, and they refer to the case, and they say that the case in that has upheld and removed the powers to give pre-award interest. They also talk about Section 42. It's a very, very serious problem, and then they finally come out and say that we actually have to amend the act. Can you go down to? And then what they say is that they say, accordingly, we wish to express our support for efforts to expeditiously rectify the problems caused by this decision. We respectfully urge for an immediate amendment to Section 33(6) of this is the interest provision of the Arbitration Act 2005 to restore the powers of arbitrator to award interest in line with the Malaysian courts pursuant to Section 11 of the Civil Law Act 1956. In addition to this, we support an urgent reconsideration and reversal of the expensive powers now assumed by the Malaysian courts to intervene in arbitral awards, or, this is very important, to repeal Sections 42 and 43. That's why I said it's quite strange that you put a question to me that, the Bar Council wants to bring back Section 42. So I don't understand. The Bar Council is the one that asked Section 42 to be
Yeah,
repealed.
Datuk, what is your view regarding the recent proposal made by the Malaysian Bar Council to reincarnate or to reinstate Section 42 of that has been repealed in 2018? Is this
I
the way
think
forward
that you
for
cannot,
Malaysian arbitrations?
no, you cannot blow hot and cold. Once you said that you wanted it repealed, and then the government has considered it, and Parliament has decided repeal, and I think what it has made is that it made Malaysia a safe seat. Then now you want to reintroduce that thing, then you must have some good reasons. Only they will know what the good reasons are, because I don't know. My own thoughts is that if you want finality, there is actually Section 37. To test the setting aside of the award according to the Uncitral model law, which most countries, in fact, I think Section 42 provisions are only existing maybe in about 3 jurisdictions, and it is hardly used. Only in Malaysia, it's because of the original drafting, it became a jurisprudence by itself as a way of bringing the courts in to second guess what the arbitrators are doing. So I think there has to be some kind of finality. I think we are all entitled to our own opinion on how we want to do things, but I think we have to be very careful, because today you say we repeal it because this is the reason. Tomorrow you say we want to reintroduce it, then I think that we have a credibility problem as a safe seat, because with the repeal of Section 42, we have not had problems. I don't see any serious problems other than, I suppose, less court work available for parties to challenge an arbitral award other than Section 37. But if we bring back Section 42, the intersection between Section 42 and Section 37, there may be a situation there is going to be a lot of litigation. I think one of the things that arbitration under the model law it does is try to bring some finality to it. As long as parties are treated with equality and there is due process, and then the law or the arbitral tribunal writes out an enforceable award and gives its reasons. So the finality is there. It is different from the courts. The courts is an appeal system. If you are not happy with the court's a high court decision, you go to the Court of Appeal. And the Court of Appeal may give you its interpretation or set aside or whatever it is. Then if you're not happy with the Court of Appeal, you go to the Federal Court, who will make the final determinative thing. But in the case of arbitration, it is, if you are not happy with it, of course you can go under Section 37 and the grounds are limited. It is not to litigate the entire argument just before the court again. So I think that is where the difference. But anyway, my main statement is basically that it's the Bar Council who asked for it. And if now the Bar Council is asking back for it again, it is for the Bar Council to justify it, because at that moment, they were very clear about it. In fact, the repeal of Section 42 and 43 was basically asked by them. And I think, I believe, in fact, in my book, I write it in quite detail, why I think it is good for safe seat principle. It may mean that there is less income for lawyers, but it basically brings back finality. But I think the other way of doing this is to actually train your arbitrators well. Choose your arbitrators well. If the arbitrators are bad, then you have to live with it. But as long as the award is enforceable, then you have to deal with it, because you cannot nitpick and say this question you got it wrong, this question you got it right. At the end of it is all about interpretation. So I think business people will be happy, but I also want to say that this amendment, that Section 42 being repealed, is consistent with about 41 well-known jurisdictions around the world. So you cannot say that Malaysia is an odd one out. In fact, having Section 42, we were the odd one out without a leave provision or a threshold arrangement. Thank you, Dr. Shahrizal.
All right. Thank you, Datuk, for your insightful view of Section 42 that no longer there in the Arbitration Act after it was amended in 2018. Now, before I move on to the next question, I would like to share my personal encounter with you and also with the audience regarding the Far East Holdings and Majlis Ugama Islam and Adat Resam Melayu Pahang case. In my first arbitrations, during the hearings, the lead counsel for the claimants made an oral applications to amend the points of claim to include a pre-award interest, which was not there when he first drafted the original points of claim, was only on the post-award interest. And he disclosed to me, he's a very, very senior figure in the legal fraternity, and he disclosed to me that he was in fact the arbitrator for this Far East Holdings Majlis Agama Islam Adat Resam Melayu Pahang case. So he was the arbitrator for this case that went all the way to the federal court, and after the federal court judgments out in 2018, so he made an oral application to include pre-award interest and allow that oral amendment to his point of claim to add on pre-award alongside the post-award interest. Okay, so that was my personal encounter with Far East case in 2018, in my first ever arbitrations. Now, next questions. Datuk, please share with us your recent manuscript, your recent book entitled Law, Practice and Procedure that was written for China market.
Thank you. Thank you. In fact, I think you would have received a soft copy of the Chinese text of the book. It was actually a translation of my Law, Practice and Procedure book. And it is published in China now as in translation. So I think that's a first plus point for Malaysia. So you have a Malaysian text which has been published in China, and we have made it available free. In fact, my plan was basically to show the Chinese. In fact, we have the number of Chinese companies that are in Malaysia, and they are all over Asia, but they don't know what they may or may not know because they depend on local practitioners. They tend to gravitate towards Singapore. They also tend to gravitate towards Hong Kong or ICC when they deal with it. I think some of them at my time were already gravitating. We were having a big plan to be the Belt and Road hub outside of China. So we were already in talks with China at that time. But then, at that time, I started the translation arrangements, trying to translate a Chinese text of that book. Unfortunately, the events of 2018 brought a stop to it, and eventually, in 2019, late 19 and 2020, we finished the translation. So when the translation was finished, it was actually published through, and then in China, and also it's published, made available in soft copy. So, and I have actually given a license to AIADR to give it away free. So, because it's something that is new, because this is the first arbitration book showcasing Malaysia, showcasing the way things are done, the law and all. Although it's 2016, doesn't have the 2018 amendments, but more importantly, they have a book that they can actually read, which is in the Mandarin, which is in Chinese. So Chinese companies, we hope, and Chinese practitioners will become interested and perhaps use our book as a way to, because textbooks are extremely important. It doesn't matter. You see, like in Malaysia, what textbooks do we use? If you study arbitration, we still use Redfern and Hunter, we still use Gary Bond, we still use Galiard, and then we still use Russell. Then people may start to use my book, but this is where we try to do that. So this was the plan. It was meant to share knowledge, in the widest spoken and used language of the world, which is actually Chinese.
All right, Datuk, in your opinion, why arbitration is such an important dispute resolution forum for China? Perhaps from their business practice or from their legal culture, why arbitrations attractive to them?
China has the most number of arbitral institutions domestically. They have 230 arbitral institutions, which they call arbitral commissions, which does all their commercial and mostly domestic arbitrations. We are talking about hundreds of thousands of cases because of their China's development as a legal force. Actually, modernization took place in the 70s, 80s after the Cultural Revolution, and then they set up basic law, and their court system could not cope with the tremendous investment and growth they had. So they had to set up these arbitral commissions to handle all the disputes, especially locally. In fact, I think they are very, very organized to handle their disputes in their country itself, because first thing in China, there is no such thing as ad hoc arbitration, only institutional arbitration. So it means you must go to a recognized institution. They have 230. Some of them are international in nature, like CTAC and Beijing Arbitration Commission, let's say Shanghai Arbitration Commission, but many of them are basically local. Now, the way they do all kinds of disputes, everything from maritime to this one, but mostly involving domestic parties, where international parties, they have not had the reach yet. And because last time China does not go out, Chinese parties don't go out. After the Belt and Road, President Xi's Belt and Road, many of them have started to go out. And you find that Chinese companies, when they go out for a strategic reason. Sometimes you wonder their pricing policy. I give you an example. If they do, they bid for a job, you find that inevitably their price is the lowest. Sometimes you wonder how they can do the job, but they will do the job. They will lose money, but they may even get into disputes. And when they get into disputes, their attitude is slightly different from ours. They try not to fight. They will try to mediate. They will try to prevent. I think this is what we have been trying to tap into. And you will look at how, I think most of the contractors in Malaysia now, international contractors, are all Chinese. Maybe the Koreans are left, but mostly Chinese. I don't see any other people. Most of the other foreign international contractors are no more there. And maybe they are subcons or whatever it is. But Chinese are the main contractors. They seem to have the financial powers. They are here to stay. There is actually a very big national program which is of strategic importance to them, which is actually the Belt and Road. And we have to tie into that. I think all of us want to tie in. In 2018, we had an arrangement with the Chinese authorities. They were planning to set up IPACSO. They did set up IPACSO, which is the International Commercial Arbitration Dispute Resolution Settlement Organization, which is their international body. And I think AIADR is one of the council. We are one of the on the advisory board. They have a governing council. They have a rules council and an advisory council. Originally we wanted to make Malaysia a hub for their Belt and Road as they are going out. They are going to go out. They will have a strategy. So we need to go into that. That is why I think the Chinese book is important. Connecting with them is important because they are going out. They will look for institutions that are neutral. They will also try to imprint their own attitude towards the dispute resolution, and wherever possible, they will try to bring it back to China. So basically, or to a Chinese entity. So we need to be part of that. While we can offer services and we can think that we are able to do it, we will be very small. I think now we are actually moving to become, we are shrinking again. So we need to actually expand.
Okay, thank you, Datuk. Datuk, I have a more general question for you now regarding the role of the library. So as you know, a library is the heart of every university that collects physical and also e-books. In your view, how to make it attractive? How to attract the borrower to borrow and to refer to these vast collections of materials?
It depends whether you love books. I love books, but in fact, in my house, I have about 40,000 books. So in fact, I think that it's called a gentle madness if you love books, basically gila sikit lah. But that most people are like that. For law libraries, I think it's more of a resource center. And then I think we try to get people to read. So you normally I think in Malaysia particularly we all depend on lecture notes. In fact, I remember teaching even a LLM in MU. If you don't give lecture notes, everybody panic. So I think reading is not a very big thing, but I think libraries play a very important role. So what has to happen is that first thing is that you must have an attitude that it is accessible. Library is accessible, easy to go in. You can look at the books, you can see the thing, except the ones, let's say, red dots or whatever it is. You can actually have book launches like what you're doing now, like Bicara, Buku. You can have book launches. Library itself tries to do that. Then reviews. Let's say you have reviews and all these things, may have a news flash that this review is being done. And then information that what are the important books. So may come out with, let's say, a list of books or material that are actually award-winning. We have all these books, you should read this. So then moving on, then lending. Lending, I know that it's very difficult because our fellows are, once you lend, they may not return. So you may have to actually have, but you still have to be generous, expect the lending policy to be a bit thing. And then now I think it's even easier because of the e-copies. In fact, when I was in the center, I set out a research, LexisNexis and all the data bank. You could come to our library and do your research there. And you have access through the center's database and all these subscriptions you have. So let's say you don't have, let's say, the Global Arbitration Review subscription, and you want to read that, you come to the library and use it, and you can read it because we have a subscription. So then I think like what you're doing, invite authors to talk about their books and create an interest in the book itself.
Okay, thank you, Datuk. Yeah, coming back to your book, Uncitral Model Law and Arbitration's Rules. Who are the target readers of this book and how to get one?
Okay, my book was actually written that time to promote the center and Malaysia. Of course, it's Malaysian centric. I think this is the first time you have a commentary on an act that is so thick, on an arbitration act. And basically, it is meant for arbitrators, it is meant for lawyers, it is also meant for the courts, and then students who are interested in arbitration and the act, professionals, generally sometimes people who are outside the system, they need advice, they may want to actually also have a copy, and generally available in the library as a resource material. So basically, I suggest that if you are an aspiring lawyer or person in any other industry wants to know about arbitration, and the first thing is to understand is the law. What is the law? Once you read, you see, our law, the Uncitral Model Law, as enacted by the Arbitration Act 2005, amended 11 and 18, is actually a complete ecosystem. From the law, you read it, you already know how the arbitration is done. Because it's chronological, it tells you definitions, who are arbitrators, what is the procedure, who is court, and all these things. The next thing it goes through, how do you start an arbitration, what you have to file, and what you have to do. Then next one is the procedure at the hearing, and then you will have default proceedings and all these things. So when you read the act itself, you already know the arbitration system. And then you just have to fill in the rest. So I think, a person who wants to know something, of course, he's in great detail with the cases and all these things. So if you want to know generally, you just go through the act. And then if you want to know in detail, then you go through the chapters. So I think that's the way.
Okay. Thank you, Datuk. I have one last question before we can take up some question from the floor, if any, afterwards. Datuk, I understand that you have been working on an arbitrations book for India. You have done for the China market. Now you are aiming for India market. So that Indian edition will be published by Sweet and Maxwell this year. Now, would you like to share with us about that particular book and your current projects?
Okay. No, the Indian book is actually because I got tired of writing for Malaysia because nobody is reading it. You can only write so much. Like, Malaysia is such a small country. We always think that we are very big. We are in the center of the world. We are in the center of the world, but we are not very big. In fact, it's interesting that we look around us. We are being outs. We are not as glamorous as we used to be. In fact, the competition is getting harder. I of course, my interest is because we are always been the halfway house where China and India meets. You see, if you look at our country, it is a product of our history, because the communities in Malaysia are basically a product of our history because of the two great powers and centers, China and India, meeting in the center. And it's all about business and trade and economic growth. So I did China. China is a language issue. So to do a Chinese book, you have to write in Mandarin. So I can only do a translation because I can't write in Mandarin. I can't write in Chinese. So what is the next one? And Chinese system is they are a closed shop system. That means the arbitral structure is that they have institutional arbitration 100%. They don't recognize anything. That means in their country, there is only one type of arbitration, no ad hoc arbitration. Now, India is the complete opposite. And India is the second largest population in terms of population, the size. Then it is also a great economic power that is growing. And there is actually a lot of arbitrations that are going on in India, and most of it is ad hoc because they don't have an institutional structure. The Indian government has now come out with a plan that they want to make India a hub for arbitration. So I think, when somebody doesn't read your books anymore in Malaysia, what do? You actually stop writing for them. So I decided to write for India. It is quite challenging to write for a different jurisdiction, but also shows your skill sets and management abilities. So what I did was I took the base of my law practice and procedure book and then restructured the whole thing for the Indian context. So I have finished. It's 51 chapters. It's about 1,600 pages easily. And it is now going into editing. It is a thoroughly Indian book, but I have an editorial team, a young senior board and a junior board. I started off with students. Students helped me to first structure the chapters, after which we did an intense 3 months working, and we finished the entire book in 3 months with senior people. Basically, senior meaning 2 years or 3 years postgraduate experience. Some of them have arbitration experience, but many of them are in practice. They are working, many of them are working, and they spend their spare time in the evening, which I paid them some money for it. And then I recognize them when the book comes out. I think I will donate some book to the library in UiTM, to all the law libraries, so that you have a book. So when this book comes out, I do think that Indian arbitration and then arbitration in Asia as a whole will be progressed, because the problem is that when a jurisdiction is trying to grow, the Indians have done many amendments. They did the model law in 1996, which is their arbitration act is called the Arbitration and Conciliation Act 1996. They did a major amendment in 2015, where they basically say all domestic arbitrations must be finished in 12 months plus 6 months. They first country in the world, jurisdiction, that basically say arbitration must be finished within 18 months for domestic arbitrations. International arbitration, they say, okay, originally they had the same provision. They have now amended it in 2019. And now they have 2020-21. Now they have another amendment. They have set up what is called an Arbitration Council of India. So it's very, very interesting. They are going completely the opposite direction of China. So we have these two great powers. We are standing in between. And I think ideally, because we are in the center, as a Malaysian writing, let's say on China or India, maybe we have the distance, the sufficient distance to be objective. And of course, you must be polite whenever you say anything. Especially in a foreign jurisdiction, they have their own ways of doing things. But you analyze it, and then you get what I got was my team. My team were all Indians from India, and they were excellent. The talent of India. In fact, even my team in China, the people who did the translation were excellent. I had people who are, basically committed, skillful, talented, and I think more importantly, quite visionary. They're all hungry. They are looking for things. So I think that's what the book will come out. I think now is being published. So we are actually now going through the editing process. And as a writer, the editing process are sometimes a bit painful. And then we are actually getting the forwards done. The book should be published in June or July. So it will be published in India. I will have a book launch in India. But this is my first book outside of Malaysia. I've written 8 books so far, and all of them has been for Malaysia. This is the first book I've decided to write. I think this is because of circumstances. Because if people are not interested in my book in Malaysia, why should I continue writing it? So I decided that I will go where there is interest, and the skill sets that we have. We have the skill sets. And the other one is that the latest projects, I've gone into AIADR. I'm the president, and we are doing courses, training, all these things that I'm interested in, because AIADR was set up as a membership institute for Asia. In fact, ALCO wanted Asian African Institute of ADR, but I said Africa is a bit difficult. Let's start with Asia, and we were given the honor of spearheading it in Kuala Lumpur. And so we set it up in Kuala Lumpur. Again, I think in 2018, everything collapsed. So now we are starting to keep this going. But, eventually I'm hoping that we will become a prominent membership institute where people want to join, Asians particularly, Africans or South American, or outside. This is a system that is outside the developed country, but having the same standards, skill sets, debate, and then we are doing training programs. We try to keep the cost down and then make it accessible. We are trying to do training in different languages. All these things are being done now. So it's a startup. It's actually what we would say is a brave new world that we are looking at. If Aldous Huxley talked about this brave new world, I believe the brave new world is just before us. We just have to dip in and continue. So this is some of the work that we are doing. You can see my colleagues here. They are poorly paid, but they work very hard. You can see how hard they've been working. We have so many things going on. In fact, I think this place has become I like it. It's become like a beehive. It's buzzing with energy and enthusiasm. So we will get something done. This is actually we are very fortunate. It is in Malaysia. At one point, I had to move the secretariat because there was so much resistance in Malaysia. I had to move the secretariat to Singapore. But now we brought the secretariat back to Malaysia. So we want to contribute. And it is a great honor that Malaysia has that the institution is based in Malaysia. It would be sad that we let it go because it's a big idea. In fact, I think at one point, I remember the Chinese asked me whether that we can actually give the institute to them. So I said, no, we can't do that. This is actually a Malaysian ALCO venture, and we will continue as an ALCO arrangement. But even if ALCO is not actively involved, it will take a life. And we have an international council, a council from China, people from China, from Hong Kong, last time from Korea, Singapore, Caribbean. So Malaysians, originators are Malaysians, but it is something that was never done. Very few organizations, international institutions are actually set up in Malaysia. So we have done this. So this is very important for us. It is small now, but we are working very hard. I think give us I'm very sure, give us a few years and we will be there. The footprint is already there. Thank you, Dr. Shahrizal.
All right. Thank you, Datuk, for sharing with us your inside view on the book and also on the contemporary issues of arbitration in Malaysia. Now, before I wrap up with my concluding remarks, is there any question from the audience? Any question from the floor? Is there any questions from the floor, from the chat box?
I think we overwhelmed them.
Any questions? If there's no question, then I can proceed with my concluding remarks. All right, I assume there's no question from the audience. So again, I would like to thank our honorable guest, Datuk Profesor Sundra Rajoo, for being with us. And also, my special thank goes to UiTM Perpustakaan Tun Abdul Razak, PTAR, for organizing this Bicara Buku academic discourse. And in light of the foregoing discussions, I can safely conclude that arbitration is here to stay, and Malaysia is on the right track to be the hotspot, to be the preferred hub for international arbitrations. And we are striving very hard to provide a safe seat for international users to arbitrate in Malaysia, as well as for domestic arbitration to take place with full confidence from the domestic users. And again, I thank everyone. Thank you to the audience as well for joining us, and till we meet again. Thank you very much.
Thank you so much.